Writing in 1764, Cesare Beccaria set the baseline for how the state approaches wrongdoing. Any coherent theory of crime must answer exactly two questions: which acts should be punished, and to what extent. The traditional retributivist answer is moral. The state punishes the guilty because they deserve it. The penalty must be strictly proportional to the seriousness of the wrong, regardless of the cost to society. But there is another lineage, running from Jeremy Bentham to the modern synthesis of economists like Robert Cooter. In this view, punishment is not a moral imperative. It is a strictly utilitarian tool used to minimize social costs. Push these theories to their extremes, and they fracture. Imagine two prisoners. Prisoner A committed a heinous murder, but is repentant. Prisoner B committed manslaughter, but remains violent. The utilitarian paroles the murderer because he poses zero future cost. The retributivist paroles the unrepentant man because he has paid his specific moral debt. We will leave the paradoxes to the philosophers. The economic theory treats crime as a constrained optimization problem. The state's goal is to manage wrongdoing at the absolute lowest cost. To optimize crime, we first have to define it. The traditional legal hallmarks are specific. The criminal intends harm, the harm affects the public, the state acts as the plaintiff, guilt requires a higher standard of proof, and conviction results in punishment. That higher standard, beyond a reasonable doubt, is a deliberate statistical imbalance. Following the English jurist William Blackstone, the law heavily weights the error cost of a false conviction over a false acquittal. The state tolerates type 1 errors to suppress type 2 errors. This diagram illustrates the culpability scale. It begins with careful behavior, progressing to negligence, then recklessness. Finally, it crosses into intentional harm and cruelty. That boundary is mens rea, a guilty mind. It is the exact frontier where civil fault solidifies into criminal guilt. Consider a thief who shatters a $100 car window to steal a $75 radio. Perfect compensation to the victim requires $175. Perfect disgorgement requires stripping the thief of his $75 gain. Neither is a punishment. Punishment is any penalty strictly greater than the disgorgement. By definition, punishment must leave the injurer worse off than the status quo before the crime. Otherwise, it fails as a deterrent. If civil liability forced criminals to pay for all the damage they caused, criminal law would be redundant. It isn't for three distinct reasons. The first is imperfect compensation. No amount of money restores a victim's indifference to losing an arm or losing a child. Pricing fails. Deterrence must take over. Second, even if a theoretical compensating sum existed, courts have no way to discover it. There is no market for the right to assault someone. Without a market to force preference revelation, victims cannot be trusted to state their true subjective valuations. Third, the law protects different types of entitlements. Using the Calabresi-Melamed framework, civil liability protects interests with a pay and proceed liability rule. Criminal law protects rights with a strictly forbidden property rule. It explicitly prohibits forced transfers, even with compensation, to preserve voluntary exchange. To see why liability fails, run the numbers. A thief steals a $1,000 television. He faces a 50% probability of getting caught and facing civil liability. His expected cost is $500. His gain is $1,000. Under civil liability alone, theft yields a net expected gain of $500. As Robert Cooter established in his 1984 paper, Prices and Sanctions, the law must choose its aim. A price allows you to act if you pay. A sanction is designed to stop you. If the optimal penalty scales up with premeditation or repeat offenses, the law is deterring the act, not pricing it. In 1968, Gary Becker modeled the decision to commit a crime. We assume an amoral, risk-neutral calculator. The seriousness of the crime yields a payoff, y of x. The statutory penalty is f of x, and the probability of facing that penalty is p of x. This graph maps the offender's calculus. The payoff line rises at 45 degrees. The statutory punishment sits strictly above it. But because capture is never certain, the expected punishment, probability multiplied by severity, slides below the payoff line. The rational criminal maximizes profit. He escalates the seriousness of his offense to the exact point where the vertical gap between his payoff and his expected punishment is widest. That output is X star. This is the first-order condition for the rational offender. The criminal pushes the severity of the act until the marginal benefit of an extra dollar stolen exactly matches the marginal expected cost. That cost has two parts: the change in the probability of capture multiplied by the penalty, plus the probability of capture multiplied by the change in the penalty. If we zoom out and interpret X as the total number of crimes committed across society, we derive the first law of deterrence. As expected punishment rises, aggregate crime falls. Even lab rats obey this law. The only relevant policy question is the elasticity of that supply curve. If supply is highly elastic, deterrence works. If it is inelastic, the state must look outside the justice system to variables like employment and education. Not all crimes are perfectly calculated. Many stem from momentary lapses, what economists model as Saturday night fever. In this model, an individual draws their future discount rate from a probability distribution. Most of the time, the draw is moderate, and the person obeys the law. But occasionally, they draw a wildly high discount rate. They hit a tipping point, R star, where the immediate benefit of an act completely eclipses the heavily discounted threat of future prison. That blue tail is the probability they tip into wrongdoing. We can see the mechanism of youth crime here. High emotional volatility creates a Rothschild-Stiglitz mean-preserving spread. The variance of the mood distribution widens, pushing more density into the tail and driving up the probability of a crime. As people mature, the variance shrinks. When offenders heavily discount the future, threatening them with longer sentences accomplishes nothing. A study by Lee and McCrary tracked arrest data and found no drop in offending when youths turned 18 and suddenly faced severe adult penalties. Whether from episodic moods or a systematic psychological flaw known as acrasia or hyperbolic discounting, the policy lesson is identical. For impulsive acts, remote severity is entirely discounted. Deterrence requires swift certainty. And at the absolute limit of irrationality, where the McNaughton rule recognizes true insanity, deterrence fails entirely, leaving confinement as the state's only option. The ultimate goal of criminal law is to minimize the total social cost of crime. That equals the net harm caused, plus the resources spent trying to prevent it. Calculating net harm is contentious. Most agree a starving hiker stealing bread creates a net social gain. The pleasure of a violent offender clearly does not. But the lines blur. When financier Michael Milken used high-risk junk bonds to force corporate takeovers, was he modernizing American industry or defrauding the public? Economic models clarify the trade-offs, but they cannot resolve the moral dispute over what counts as a gain. This graph maps the efficient level of deterrence. The marginal social cost of deterrence slopes up. Stopping the first few crimes is cheap, but driving crime to zero is incredibly expensive. The marginal social benefit of deterrence slopes down. The optimal point, D star, lies exactly where the two lines cross. Notice that D star is never at 100%. Long before society eradicates every last offense, the cost of adding another police officer or building another cell violently exceeds the damage of the crime they would prevent. Furthermore, George Stigler pointed out that penalties must maintain marginal deterrence. If the law prescribes life imprisonment for embezzlement, an embezzler cornered by the police has zero marginal cost to shoot his way out. Maxing out penalties for minor offenses destroys the gradient that prevents escalation. Measured, decisive. Because deterrence is physically and economically costly, a rational society must tolerate a strictly positive amount of crime. To reach that optimum, the state must balance its methods. Gary Becker showed that probability is expensive. It requires patrols, detectives, and courts. Severity, in the form of fines, is practically free to administer. Efficiency demands high fines applied with low probability, but the state quickly hits the bankruptcy constraint. Most criminals cannot afford massive fines. The justice system relies on wildly expensive incarceration only because it exhausts the financial limits of the offender. Ultimately, deterrence does not rely on the state alone. It requires the coordination of good people. Reporting crimes, testifying, and maintaining community standards are civic acts. And the cost of a civic act falls dramatically as more people participate, because there is safety in numbers. This dynamic creates multiple equilibria. If the cost of cooperating falls faster than citizens' willingness to pay for it, the math forces a corner solution. Society will cascade into either near-zero cooperation or near-universal compliance. The law's final job is to coordinate citizens into that high-compliance equilibrium. This synthesis, built on Becker in 1968 and refined by jurists like Richard Posner in 1985, strips away the moral panic. Beccaria argued the measure of crime is harm. The economic theory proves that the optimal amount of crime is a strictly positive number. Law and economics defends this mathematical reality, quietly balancing the scales, even as moralists refuse to accept the weight.